Good evening, everyone. The meeting is now live. Thank you.
Well, good evening, members, officers, visitors and members of the public. I'm Councillor Tim Gibson and I'll be chairing this evening's meeting. The meeting will be recorded and proceedings will be conducted in accordance with the Council's constitution, including procedure rules which are available on the Council's website. Item 1 on the agenda is the evacuation procedure. There is no planned evacuation drill this evening, and accordingly, if the alarm sounds, it is to be treated as a genuine need to evacuate. There are emergency exits to my right or through the passageway to my left as you leave the chamber, and then via the main staircase at the front of the building. Please note, lifts must not be used. The assembly point is on the far side of the car park outside, and it's important that you remain there and do not return to the building until I have announced that it is safe to do so. If anyone present will need assistance in evacuating and negotiating the stairs, could you please inform me now so that we can make necessary arrangements to assist you? Thank you. Just before we move into the more formal side of the meeting, I'd like to announce item 2.3 on your agenda has been withdrawn due to an agreement with the parish council, so they no longer wish to object on that. So item 2.3 has been withdrawn. It was good work, but good. Okay. The meeting has a quasi-judicial role and determines the rights and obligations of the applicant. Members must consider each application and everything that is said in the meeting concerning the application and make their decision based solely on their planning judgment of the information that's available to them. Following a decision by members, delegated authority is given to the planning officer to issue the decision notice, and planning permission is not granted until the issue of that decision notice. Any member of the council who is not a member of the planning committee may attend as a visiting member and may speak having given prior notification. Such visiting members may of course include ward members, and whilst visiting members can speak on an application, they are not permitted to vote. Any member acting as a substitute on a planning committee must have undertaken the appropriate training before doing so. Members must remain in the meeting for the whole time that each item is debated, and they should not vote on that item unless they have done so. I would now like to welcome our public speakers and remind you all that you have 3 minutes to speak, and an audible warning of time will be given when there are 30 seconds remaining. If the meeting is deferred to conduct a site meeting, you may speak both at this meeting and at the site meeting, but there will be no further opportunity to speak on the matter when it comes back to the Planning Committee. The meeting will follow the order set out in the agenda. However, I will amend the order if there's good reason for doing so. And in particular, I will take any items where a member of the public has registered to speak first, before we then move on to the remainder of the agenda. And I'll verbally reorder the agenda as we progress and as appropriate. Now take item 2, which is apologies for absence and any substitutes, please.
Thank you, Chairman. Apologies have been received from Councillor James Hunt, who is substituted by Councillor Simon Fowle, from Councillor Elliot Jays, who is substituted by Councillor Derek Carnell, from Councillor Ben Martin, who is substituted by Councillor Mike Henderson, from Councillor David Simmons, who is substituted by Councillor Nicholas Hampshire, and also from Councillor Tim Valentine and from Councillor Richard Darby. Thank you.
Thank you very much. Now move on to item 3, which is to approve the minutes of the meeting held on the 10th of March 2022, minute numbers 671 to 676 as a correct record. Thank you, members. Item 4 is to invite members' declarations of disclosable pecuniary interests under the Localism Act and disclosable non-pecuniary interests under the Code of Conduct adopted by the Council. Members, are there any such? Councillor Bonney?
Yes, thank you. Item 2.4, I shall remove myself from the meeting as it's been part of my cabinet role. It's been quite heavily discussed.
Thank you.
My work, thanks.
And Councillor Beard, please.
Can I declare a non-pecuniary in 2.5 just because my employer does business with the applicant?
Thank you. We'll now move on to item 5 of the agenda, which is this evening's deferred item, which we will now consider is item 21/500-173 and it's land east of Horswood, High Oak Hill, Iwade Road, Newington, Kent, ME9 7HY. And I'll thank the officer for outlining the application and any updates, please.
Thank you, Chairman. Good evening, everyone. I'll share my screen, then I've got a bit of an update for you. Hopefully you can all see that. That's an updated site plan of the development that's recently been provided by the applicants. The updates as follows. Members will note the tabled update. I should clarify that further to paragraph 5.2 of that update, we've now received a total of 19 further third-party comments, of which 18 were expressing support for the proposal and 1 was raising objection. I should emphasise that there is no in-principle objection to the use of land for an animal sanctuary. On the right site and with the appropriate planning controls in place, such a use would potentially be supported by officers. However, the application site is sensitively located immediately adjacent to a designated ancient woodland. These are a finite and diminishing resource nationally, which enjoy protection at a national level under the National Planning Policy Framework. The site also sits within an area of high landscape value, where special care needs to be taken to ensure that new development does not detract from the quality of the landscape. Given these designations in particular, but also the various other issues itemised in the reports before members, officers have concluded that this is not the right site for the proposed development. Careful consideration was given to the additional information provided since the application was deferred by members last December, but due to the lack of supporting specialist information and plans, and concerns raised from KCC Ecology and KCC Highways, who are still not satisfied with the information as submitted, coupled with 4 registered noise abatement breaches where environmental health investigations are ongoing, officers do not believe that sufficient information has been provided to address the previous concerns. For these reasons, officers remain of the view, as set out on pages 25 and 26 of the agenda, that the harm arising from the development would significantly and demonstrably outweigh the benefits when assessed against the local plan adopted 2017 and the National Planning Policy Framework and the other material planning considerations, and therefore it is recommended that planning permission is refused for the 5 reasons set out. Thank you, Chairman.
Thank you, Mr. Wilson. Could I now invite Amy Jones, please, the applicant, to speak on this item?
Hello everyone. Sorry, excuse my nerves. So I'm going to keep this short, which for me is not common, but I've written this speech a number of times now, and I've come to the realization that 3 minutes just unfortunately isn't long enough for me to address every single issue, allegation and flaw in this case. I think from the very beginning, when the charity's request to have a pre-planning application advice was rejected by the council, things have just not been right. Many things that have been asked of the charity have been pretty much impossible, intentionally sometimes, I believe. For example, being given just a couple of weeks to produce an in-depth ecology report, which even professional ecologists deemed impossible, as they'd need a minimum of 2 to 3 months to carry out such a survey. In the last 15 months, you name it, the charity's had it thrown at it. From the serious stuff, such as purely malicious animal welfare reports, to the plain ridiculous, like accusations of excessive mooing from the cows, and of course flying emus. The more I read the council's reports and admissions, the more inaccurate statements arise. Surely these are meant to be statements of fact based upon evidence, not allegations, hearsay or assumptions. There's no way I can address all these myself and would rather they were dealt with by a specialist law professional. I apologise, there's still some queries still outstanding and information missing, such as the exact size of the car parking area and details of the biodiversity enhancements, but these are all things that could easily be conditioned. I'm not a planner, nor am I an architect. I'm just a person who wants to help animals and people. And the Happy Pants Ranch is not a company or a business, but a registered charity that passionately promotes being kind to all kinds. It's a small sanctuary who wants to do good, flourish, and right any wrongdoings it has unintentionally made, because the charity, thousands of people who support it, and myself believe that the benefit of the work it does far outweighs the negatives, although I suppose flying emus would be quite cool. Thank you for listening. I've kept it short, and I'd just like to say those the noise breaches, there's been 4 noise breaches in 5 months, which to me does not even qualify as a frequent noise. And that's it.
Thank you, Amy. Could I now invite Councillor Woodford as ward member to speak on the item first? Thank you.
Thank you, Chair. As ward member, I previously spoke in favour of this application and my opinion has not changed. I therefore have to disagree with officers. I believe the benefits of the sanctuary do outweigh any harm. I believe this will be a massive benefit to the Swale area, and the sanctuary is vital as there's no other facilities locally that provide the same service. It provides valued animal welfare benefits and benefits for volunteers. There is a clear and overwhelming public support for the sanctuary, with many personal testimonies from individuals expressing the benefits to them and their mental health. As before, I feel the concerns raised in the report can be satisfied with conditions if planning were granted. A condition requiring an independent ecologist report and that any recommendations from that report are implemented would meet the KCC biodiversity concerns. KCC Highways have suggested their own condition within the report, allowing the visits to the sanctuary on a temporary 2-year basis so that all of the parking and traffic issues can be better monitored and addressed. The report seems to indicate the Forestry Commission are now happy that any structures have been removed from the ancient woodland buffer zone. One of the major concerns raised was the noise abatement issue. I struggle with this. The land is already agricultural land in a rural setting. The land hadn't been made use of for this purpose for many years, but surely if the landowner had wished to reinstate the use, they could have cleared the land and done so without any planning permission, as it was already designated as agricultural land. They could have easily decided to keep livestock on the site, and therefore the change of use being requested and the noise generated from the animal sanctuary isn't out of the norm for what would legally could have been expected from this location. Could officers please clarify that point? Another concern mentioned in the report several times is that animals have escaped the site and that this is well documented. Can officers please tell members where this is documented and where the evidence came from originally? Is this reports from residents, as I believe the applicant strongly disagrees with the statement? I therefore have to disagree with officers. Thank you, Chair.
Thank you very much. Could I now invite Councillor Mike Baldock, visiting member, to speak on this item, please?
Thank you, Chairman. Can you hear me?
Sorry, just hold on a second, Mike.
Apologies. In Appendix 2, and I wasn't at that first meeting, but I've read the documentation very carefully. At the top of page 48, it says the chairman moved the officer recommendation to approve, and this was seconded by Councillor Martin. My understanding is that the proposal was to refuse and not to approve. And if that's the case, I'd like to understand that.
Yeah, it was actually deferred. The recommendation, you mean, was to refuse. Yeah, so there's quite clear a typo on that at the top of page 48. You're quite right. Yes, you're quite right. Thank you. No. Yeah, thank you. We'll have that amended as well. Thank you very much. Councillor Baldock, please. You have 3 minutes to speak on this item.
Thank you, Mr. Chairman. This application is for an animal sanctuary that already provides huge benefits to the borough. A place of safety for animals with nowhere else to go, open air exercise and socialising for a number of volunteers, including very rare opportunities for disabled people. This is a massive resource for us to just reject. It is a massive benefit to the borough. Most of the points alleging harm are either lacking in proof or can be dealt with by sensible conditions. I am alarmed by the constant reference in this report to allegations or possible actions being possibly considered by other agencies. It is for those agencies to take action if they feel it appropriate and for the correct legal procedures to take place. It is not for this planning committee to be asked to prejudge any possible future actions possibly taken by other agencies. Indeed, when councillors raise such objections on other applications, they are quickly shot down by being told that this is not a planning matter. So why is this case different? Looking at the reasons for refusal, these seem somewhat odd, and most can easily be dealt with by conditions. There's talk about the harm that has been done, but who else is going to restore the land? At least this gives us an opportunity of people who are going to do some good. The buildings are no different in size and scale than could be reasonably expected if the land were in agricultural use, and the keeping of pigs or other livestock here would be noisier and allow more buildings than this is being proposed. It could be done without planning permission. The gates and fencing, which are not really very different from those seen in many rural locations, can again be dealt with by conditions. The applicants can appeal it if they don't like the condition, and the named inspector can decide. Objection 4 asks the committee to predetermine a non-planning matter. As I mentioned, far worse could be introduced to the site as agricultural land without planning permission needed. As for the open day, this is again quite easily dealt with by a temporary condition as suggested by Kent County Council. I fear this reason would be laughed out of court at an appeal. The bottom line is, do the benefits outweigh the harm? The loss of a place of safety for animals with nowhere to go, volunteer benefits and disabled experiences, which are very rare provisions which this council has no plans to replace anywhere else in the borough, against some alleged noise some gates we don't like, and some environmental harm already committed, and which the council has no idea how it could be restored. Let's not quibble about fences. Animals' lives are at stake. The balance is clear. The future benefits massively outweigh the potential possible future harm. I would urge the committee to please support this application.
Thank you, Councillor Baldock. I now move the.
I would like to speak on items 2.2, 2.4 and 2.5. Thank you.
And I would like to consider that and get back to you. Thank you, Councillor Baldock. I now move the officer recommendation to refuse. Could I have a seconder, please? Councillor Henderson, thank you. Councillor Winkles.
Thank you, Chair. Yes, I do concur with the two ward councillors on this one. That people are saying there's complaints about noises coming from animals. Well, in a rural area, animals do make a noise. That is part of a rural community. There's basically 19 people in favour of this and one objection. So my feeling on this one is I will be going against the officer's recommendation.
Thank you. Councillor Fowle, please.
Thank you, Chairman. I was not here when this was first discussed, but sometimes I feel we look at the rules and conditions, but we forget about compassion. Animal welfare is needed in this age. We only have to look at the numerous dogs being found in Lower Halstow and elsewhere in terrible conditions in our borough. As I believe for sometimes compassion has deserted this world, and I do not want to follow that path, and for that reason I will support this application.
Thank you, Councillor Fowle. However, animal welfare isn't a planning consideration, and we're here to do the planning element. As difficult as that is.
I'm just trying to say compassion at the moment.
Yeah, okay, thank you. Councillor Henderson, please.
Yeah, I wasn't at the first of these meetings, but have looked at the paperwork very carefully, and I would like to put a different point of view. We're talking about looking after animals, and I absolutely applaud the wish of this charity to do that. However, if we're going to talk about protecting animals, we must talk about protecting the whole of biodiversity. And the fact remains, and this is not an opinion from officers, and not a this was reported, a considerable amount of damage, and I would suggest probably irreparable damage in the immediate future, has been done to the edge of an ancient woodland, and ancient woodlands are nationally protected and nationally important for biodiversity, and damage has been done to the site itself in terms of hardcore laid there. So it would be very difficult actually to return it to being farmland. That has damaged biodiversity. And I believe damage has also been done to ponds and waterways. And however we may feel about allowing this to happen, that none of that should have happened, and we cannot just ignore it. There are other problems about noise and about traffic, and certainly I'm very concerned that there is precious little information about how much traffic would be generated immediately and then later on. I'm less worried about noise, but certainly there are cases where that's a problem. And we have a very clear recommendation with a lot of sound information provided to us, and we need to make a decision on planning grounds. And so I would suggest, Mr. Chairman, that we make that decision on planning grounds. And if we do, then it should be a decision to refuse. Thank you very much.
Thank you very much. Councillor Dender, please.
Thank you, Chair. Yes, I remember the last meeting where we discussed this, and I was one of the ones that, I can't remember if I proposed or seconded the deferral, because I felt that they should have a chance. Like everybody says, we have to show some compassion. We do need somewhere for animals, a rescue of animals and so on. And I thought they should have a chance to redeem that and do more to mitigate what they'd already done, in fact. However, that has not happened. They had 3 months. They've actually ended up with 4.5 months because of stretching it. And I totally concur with Councillor Henderson on virtually every point. A lot of biodiversity has been destroyed, irreparably destroyed, I believe. The ancient woodland has been treated, and that isn't a matter of knowledge, it's a matter of common sense. That's been treated abysmally. The corridor to the ancient woodland was not left, and you could look up on the internet and find that out in 15 minutes flat. That's not difficult. So I think there was a lot of rush to get on that site and not a lot of research into what was needed to have the site ready and appropriate for animals. So I'm sorry, but I don't believe enough work has been done since we deferred it. And I totally agree with the office. And I would commend the officers. They've done a massive amount of work during the deferral period and come up with almost all the information we asked for. And I would commend them for that. I was hoping, I really was hoping that they would come up with something that would make me able to say that I would support it. Unfortunately, that hasn't happened. I therefore would go with the officer's recommendation of refusal. Thank you.
Okay, thank you. Members, anybody else wish to speak? Councillor Marchington, please.
Yes, thank you, Chair. I don't think tonight is an issue about what the good the charity does, which is exceptionally good, and we'd like to see it. But it's all about the ancient woodland buffer zone, and there are currently many miles in this country been designated to protect woodland, and they are now at threat. You win in one place, you win everywhere, and that's a fact. And the often statement towards disused ground, because it's actually what it is, the buffer zone is to return it back to its natural habitat. And I can go back quite a few years ago, where I often used to go the other side of Detling to watch the deer when they come out of the woodlands at night. They come out into the grass, and you'll see them, they're watching, and then they'll just suddenly drop into the grass to sleep at night. That's the natural way deer work. They'll hide in the woodland when they're not running around foraging, and they come out into the grass to sleep at night. And there'll be no chance of them ever doing that here. So the deer will be lost to that wood for a fact. So I would like to see some better organised system where this charity can find another site or get assistance to get another site, because it does seriously good, but also the ancient woodland and the buffer zones must be preserved, and I have to stand by that one. I'm sorry.
Thank you. Councillor Burt, please.
Yeah, thank you, Chairman. Firstly, I welcome Councillor Henderson's sound views back to this committee. Certainly when he was here previously, his knowledge of native species and flora and fauna were almost all legendary and welcomed at this committee. So thank you. Mr. Wilson's been flicking through photos. I noticed he's got about 12 there that he's put us in, and I just wonder if we could quickly flick through those, because clearly they are there as presentation photos and we've only seen a couple of them. But I do concur with the last couple of speakers that very little was changed here since the last time we looked at this 4.5 months ago. In fact, more material has been brought onto the site. You can see from these photos, whilst I, like Councillor Martinson said, whilst we can all agree with the aims of the charity and we can all show compassion like Councillor Fowl says, at the moment, that site is not acceptable in planning terms at all. I have concerns about some of the comments that have been made as well that aren't relevant to planning, but also the fact that there was a mention of there's been 17 letters of support and only one objection. Well, one of the objections I've seen was from 6 people or 5 people, and they were 5 people who live nearby. When you actually go through some of the letters of support, they're from as far afield as Norfolk and Cornwall. You will have to take some relevance, I think, to what we're being told. I mean, you just need to look at some of these photos. It's not acceptable at all, and I think the officers have done a sterling job, sterling report, and I will be supporting their recommendation.
Thank you. Mr. Wilson, could you just run us through those photos that you got?
Thank you, Chairman. I'm up to number 6. As you can see, this one shows hard standing and a couple of caravans and some like horse boxes and other paraphernalia. Just flick through them. There's only 11. That's along the side of the site next to the Horswood ancient woodland. That's a close up again with the ancient woodland immediately behind it in the background. This one is of some of the bird enclosures. I believe that's an emu, but don't quote me on that. That's a close up of some of a small amount of rubbish on the site. And that's another one showing some of the material. Just to say, these photos were taken by Kevin Tucker in the environmental health team, and as members may be aware, he's on the call if there are any queries about noise or other environmental health issues. That's it. They're the photos that were picked out from the ones that were taken recently by officers.
Thank you. And were you able to offer any answers to issues that were raised by Councillor Corey Woodford?
Just sort of referring back through my notes, I think one was about the agricultural status and whether this development was really any, particularly different from a potential agricultural use of the land. And I mean, I suppose the obvious difference to draw out is, I suppose one of the differences relates to the intensity of the use, and as set out in the committee report, the sheer number and diversity of animals that are kept in quite a tight proximity and relatively close to the nearest neighbouring dwelling. I mean, that in my experience, I mean, you could get an example of a farm where that might be the case, but generally it certainly wouldn't be that diversity of animal species combined with that density of animal species. I mean, I suppose the other sort of obvious thing to say that makes this different in terms of the overall planning balance, if you like, is the fact that it's a combination of animals being kept on the site, as I've been saying, but also of the fact that it's an animal sanctuary intended for public visits, which have implications that are different, obviously different from a farm, and the other factor, which I think is certainly relevant to raise, and some of the members have mentioned this already, is the fact that it's adjoining an ancient woodland, which, as I said in my introduction, has protection under the National Planning Policy Framework, because ancient woodland, as at least one of the members has said, is at a national level, certainly, it's it's a diminishing resource, and we need to treasure it so that as a society we're not handing on less of it to future generations. And it's important to sort of mention that again, because if we had any planning application for development that was within the 50-metre, part of it was within the 50-metre buffer of an ancient woodland, I'm sure that we'd be raising that as a concern with the applicants, be it say even if it was an application for an agricultural building, you know, would be very unlikely to find that to be acceptable. So in answer to certainly in answer to that question, I think there are a number of things that make this different from a sort of default position of the land, using the land for agriculture. I think there may also be mention of noise, but if that amongst her comments, and apologies for being slightly vague, but if that was the case, then potentially that's something that environmental health might like to comment on. And the last thing I'd like to say is a number of officers have looked at this case because it is an important case, not just the case officer, not just myself, but Mr. Jeffers, who's on the call, and our head of planning. And you know, we've given this very careful consideration as we give to all planning applications, and the decision to recommend refusal certainly wasn't reached lightly. And if we thought there was any possibility of coming up with an approval that was tightly conditioned, then we would have looked at, you know, we would have gone with that. But to be clear with members, that we didn't feel it was a clear-cut case, unfortunately, in that regard. We felt, and we continue to consider, that it's the appropriate course of action, regrettably, is for the application to be refused, and on those reasons that are set out for members in the report. Apologies if that was slightly overlong.
No, that's fine. Thank you. Could I now invite Councillor Stephen, please, to speak on this item?
Thank you, Chair. This is a charity and doing what we all want charities to do, and that is to do a good job looking after animals. They are obviously, their funding is limited, and I do agree with the officers that insufficient information and conditions have not been met, but we could set conditions, time limited conditions, on all the outstanding problems that the officers have highlighted. And I do feel that on compassionate grounds, they deserve it. And I think as a council, we are in a position to help them here. I mean, finding more land for them now, as we all know, is almost impossible. They've got a piece of land. Yes, it needs a lot of work. It's got a lot of rubble, and it doesn't look great, but it can be made to look good. But that takes time and money. And these people obviously haven't got that money, but what they do have is time, and they could have a council that could help them with the time and a condition that it's done on a certain basis. And I don't even know whether we can give them a temporary measure, application to agree to stay there for a certain amount of time, so long as these conditions are met. And I would hope that the council could consider that.
Thank you. I'll come back to that in a second. Councillor Bonney, please.
Cheers, thank you. I wasn't at the previous meeting for this application. If I could just ask the officer a couple of things. I think it was raised earlier, but I'd just like to understand. The ecology report, it was mentioned by the applicant that they hadn't had time to do this. I know they take some time. How long have they had to provide this information? In terms of what's happened on site, I am really concerned about the state of it and the bit that's next to the ancient woodland, what appears to be the buffer zone with this, I don't know what you would call this stuff, but it's not part of the natural environment, and it appears to have a lot of rubbish on it. I mean, is that actually engineering works on the site, and would that require planning permission? And if this was agricultural land, would this require planning permission? Because I know farmers are allowed to re-level up to a certain point, and I remember asking an officer this question a couple of years ago, but I can't remember what the answer was.
Okay, we'll endeavour to find that one out. Councillor Beer, please.
I was going to take up Mr. Wilson's offer and just ask if we could hear from Environmental Health, because I think their points in 4.3, it mentions that it's been independently looked at by 4 officers on 4 separate occasions, and they still reached that the use of the site is untenable, and they put in a strong objection. Given the photos of what is builders' rubble that has been brought onto this site, it's not clean inert soil, it is clearly builders' rubble. I'd like to hear from Environmental Health, please, if they're on the call.
You'll get that opportunity after the next speakers. Councillor Dender,
sorry, yeah, just to add that, if you're going to ask the question, Mr. Wilson, because I think it's relevant to what Cameron, Mr. Beard says and so on. I would also like to point out that whilst the waste, the contamination of the waste is actually an environmental agency matter, it's not a planning control.
Yes, absolutely. Yeah.
I would like Mr. Wilson maybe to give an opinion, listening to Councillor Bonney. I believe the way the waste is put there has changed the topology of the land. And I'm not sure if I'm correct, but I believe it may affect surface drainage for flooding onto the road. And I'd like an opinion from the officers on that, if we can get to that at some stage.
Yes, we will very shortly. Thank you.
Yeah.
Councillor Winkles.
Thank you, Chair. I would like some further clarification from the officer on this. They still didn't answer about where the well-documented evidence of animals escaping is recalled and where it came from. Now, that is been an allegation that has been made. Can the officer give us some more detail on that, please?
Right, okay. So first of all, I'll bring in our environmental officer, if you could, please.
Thank you, Chairman, members. If I first pick up the comment about it's not out of the norm to have noise on agricultural land from livestock. And to a certain extent, I acknowledge that. Unfortunately, the main issue of noise has been from the cockerels and geese, and cockerels in particular. And I've known that area for over 20 years, actually, so I'm quite familiar with the sounds of that part of the world. And 120 cockerels is not the norm on an individual farm, let alone general agricultural land. And this isn't incidentally alleged noise, this is facts. I've witnessed it, other officers have witnessed it. It resulted in abatement notices for animal noise, including cockerels and geese. And we've substantiated breaches of that. Various officers have substantiated breaches of that. And in fact, I was on the site on Tuesday, and Amy will recall the conversation. Sorry, the applicant Amy will recall the conversation. Sorry, Amy, where we talked about the number of cockerels on the site and the reasons why there were so many cockerels, and they are so noisy. They are just incredibly noisy constantly. And the explanation that was offered to me, of course, was that no other sanctuaries will take cockerels, so they've ended up here. And I did express my real concern that this was going to be an ongoing issue. Perpetual noise from cockerels was just going to be continuous in terms of nuisance, because of course we haven't really acknowledged the fact that there are 3 families immediately adjacent to this site, and they've lived there many years, and they are the ones that are suffering excessive noise nuisance, which has resulted in this action. And I think that's probably made it clear that whatever you do on the site there, all the while there are cockerels and geese, there will be noise issues, because I don't see any way with that type of animal kept on the site that there will not be an issue at some time or other. If it's not an issue to people living on the east of the site, it'll be a problem to the west of the site, depending on the wind direction, of course. And that's really, I don't know if that's helpful, but
yeah, thank you. And Mr. Wilson, could you help us out with the questions posed by Councillor Stephen and then Councillor Bonney and Councillor Winkles, please?
This is going to be a good test of my not very reliable memory, so let me know if I haven't answered any of the questions. I think sort of one of Councillor Stephen's questions was about could we not use conditions and approve a tightly conditioned scheme potentially for a temporary period. My view on that, as I said previously, is that officers don't believe that would be appropriate in this instance because we consider that this is an application that unfortunately we recommend should be refused. Councillor Bonney, first question was about the additional information, and there was reference to an ecology report. I draw members' attention to one of the appendices, Appendix 3, on pages 51 to 53, which is Mr. Freeman's letter following the committee in December last year, which sets out the extra information that was required, and in there the main piece of work, rather than an ecology report as such, was a management plan. And then Mr. Freeman sets out what the sort of various elements of that management plan might be. But in terms of the answer about how long the applicant had to provide additional information, I mean, the letter went out on the 21st of December, and I think it's set out in the report. We subsequently, well, we were hoping to get the application back to committee within 3 months of the December committee, but as one of the councillors said, I think we're slightly, around about 4 months.
That is within the report.
Sorry?
That is within the body of the report.
So in terms of the amount of time given to the applicant, although I appreciate that sort of, these reports do take some time. I mean, as officers, we were of the view that sufficient time was given for that information to be pulled together and reported back to this meeting. And obviously, there's a balance in terms of we knew that the members wanted to see the application back rather than letting it run on and on. So we think that the approach to that was reasonable. And then I think there's the question about the imported material, the hardcore, etc., and whether that was an engineering operation in terms of the way we dealt with it. Two things to say on page 40. Well, it's several. There's two. The pages where the refusal reasons are set out. In reason 1, reference is made to inappropriate use of hardcore materials. So the issue is captured in the refusal reason. But the other thing to say is we were looking at the planning application submitted, and the description is at the beginning of the report on page 29, and it doesn't include land raising or the importation of hardcore materials. So what I'd potentially say on that is, as I say, there's reference in the first refusal reason, but it is dealt with the way it's dealt with because land raising wasn't part of the application. I'm mindful, among other things, that, as at least one member said, the Environment Agency have sort of they're looking at this matter separately, and they'll decide in due course whether to pursue any issues of imported material under their own legislation separate from planning. And the last question I've got was Councillor Winkles asking, I think, about evidence in respect of escaping animals. And I think the main point I'd make in that respect is that we're not relying on potential instances of animals escaping, domesticated animals, if you like, escaping from the site. and harming biodiversity, specifically in the ancient woodland, we don't rely on that in support of any of the refusal reasons. The refusal reasons have been produced based on officers' assessment in the round and looking at the comments from KCC Ecology. So, yeah, that I think is all I'd like to say in that regard. Thank you, Chairman.
Thank you very much. I'd just like to bring our legal officer in now, if I may.
Thank you, Chairman. Yeah, if committee could just indulge me for a couple of moments. This is a regulatory committee. It deals with planning issues. As the chairman introduces at the start of every meeting, it's here to look at planning issues, planning merits. It's not here to discuss things or form decisions on the basis of things that are not material planning considerations. My role on the committee here is to make sure that the committee is making sound and legally compliant decisions. So I've been sitting listening to everything that's been said, and if the committee will indulge me briefly, it'll take a couple of minutes. I'm just going to read to you from the NPPF, National Planning Policy Framework. Bearing in mind we're looking at a retrospective application here, this is something that's happened already, so we have seen what is on site, we have heard from consultees what has gone on, we have photographs, so we have a real clear idea of what is happening on that site at the moment. There's also all of the statutory consultee responses and the officer's appraisal in the report, so if you can just have that in your mind. I'm going to read from the NPPF. There are a couple of sub-paragraphs that aren't relevant, so I'll just move beyond those and explain why, but I'm just going to read that now. And this is paragraph 180. When determining planning applications, local planning authorities should apply the following principles. A, if significant harm to biodiversity resulting from a development cannot be avoided through locating on an alternative site with less harmful impacts, adequately mitigated or as a last resort compensated for, then planning permission should be refused. Paragraph B is all about sites of scientific interest. This isn't one, so I'm not going to read that paragraph. C, development resulting in the loss or deterioration of irreplaceable habitats such as ancient woodland and ancient or veteran trees should be refused unless there are wholly exceptional reasons. And there's a footnote. The footnote says these are nationally significant infrastructure projects, orders under the Transport and Work Act, hybrid bills, etc., or where public benefits would clearly outweigh the loss or deterioration. And this is the second part of that paragraph, and a suitable compensation strategy exists. And then subparagraph D, again, not relevant because that's about sites that are enhancing biodiversity. That's not what this application is about. It's not a site specifically to enhance biodiversity. So we have 2 points there. If there is significant harm to biodiversity from the development that cannot be alternatively located somewhere else, adequately mitigated or compensated for as a last resort, planning permission should be refused. And if it results in the loss or deterioration of irreplaceable habitats such as ancient woodland, you would need to either refuse or set out that there are wholly exceptional reasons. And so if you are minded to approve on that basis this evening, that must be demonstrated. You must demonstrate what those wholly exceptional reasons are. I'll leave it there. Thank you.
Thank you. Members, I don't see anybody else indicating. So we'll take this one to the vote then, please. Those in favour of the officer's recommendation for refusal? Sorry, can we just do it again, members, please? Those against? And abstentions? So members, there are 9 for refusal, 5 against refusal, and 1 abstention. So permission is refused. Thank you. Right, as I said earlier, we're now going to move on to item 2.5 if we can, because we've got speakers on that one. Yes, yeah. Yeah, I'll let them go. Thank you, Nick. Members, just whilst we're waiting for Councillor Dender to return, so we're going to do 2-5 and then 3-1 and 3-2. So that's going to be the order, and then we'll go back to the order as set out in the agenda. So it's going to be 2-5, 3-1 and 3-2. Okay, I think we're going to have to press on. So item 2.5, which is 20/502/715 and this one is bobbing car breakers, Sheppey Way bobbing. And I'll thank the officer for an outline and any updates, please.
Thank you, Chair, and good evening, members. So this is an application for the redevelopment of bobbing car breakers for an outline consent with all matters reserved for up to 16 residential units. Members will note the tabled update, which covers comments from the open space manager requesting additional contributions for formal sport and play provision, and some updates to the affordable housing provision that would be requested. These would all be secured via section 106. No further comments have been received since the tabled update. I'll just give you a very brief overview of the site, if I can share my screen. Okay, so the site currently forms a car breaker's yard and is subject to a number of outbuildings, stacked vehicles and other associated paraphernalia. The site's located in the open countryside between Bobbing to the south, Iway to the north and Sittingbourne to the east. This is an artist's impression of what the site could potentially be developed to achieve. And this is another general artist's impression. Obviously, it's outlined with all matters reserved, but just some indicative images for you there. And then here we have some images of the site. So this is a picture of the site frontage facing north towards Iwade. And then this is an internal photo of the site. So we're looking here towards the southern boundary. Again, some further photos inside the site, noting sort of outbuildings and the paraphernalia associated with the breakers yard. Again, just further images as we walk around the site. And this is an image of Pheasants Farmhouse, which is a listed building which is located to the south, and you can see it indicated there by the arrow just to the south of the site. The proposal is considered to result in benefits to the local environment, and these are addressed in the committee report and address an identified housing need. The recommendation to approve is set out, and I draw members' attention to the committee papers and recommendations. Thank you for letting me speak.
Thank you very much. Okay, could I invite Mr. Peter Court, please, to speak on this item?
Thank you, Chairman. Good evening, councillors. As you've heard, this is an outline application for the redevelopment of a car breaker's yard for residential use. The site itself is unattractive. It's a brownfield site, and in reality, it is too small in terms of the modern day requirements for such a use. Now, although this application is an outline proposal, and I need to stress it is only an outline application, we've nevertheless worked very closely with officers and other parties to provide a considerable amount of additional information, including a development brief for this site. Now, with regard to planning policy, the redevelopment of brownfield sites such as this is very much in accordance with your own policies and with those of the national government. I'd like to add that you are under substantial pressure to find a considerable amount of greenfield land to meet your housing requirements. And as we all know, this leads to strong objections from local people and from other organisations. Moreover, I've recently heard that you've issued another call for sites. Now, by permitting this site, you're giving a clear indication that you're going to do your utmost to make good use of brownfield land in order to meet your housing requirements. That, I think, is a very important message. Overall, I consider that with the help and advice of your officers, we have produced a very attractive proposal that is a vast improvement on what is currently there. In these circumstances, ladies and gentlemen, I would ask that you grant planning permission. Thank you.
Thank you, Mr. Court. Could I now invite Councillor Woodford, please, to speak on this item as a ward member?
Thank you, Chair. My concerns with this application centre around its position. The redevelopment of a brownfield site is generally something I would wish to support. However, on this occasion, the location of the breakers yard is outside any built-up area. Mine and the parish council's major concern is that the development would be located within an important countryside gap between Bobbin and Iwade. This is very important, and any erosion of this could then lead to further applications and have a detrimental effect on the quality and character of the countryside. The report to committee, however, states that to the west of the site, an allocated countryside gap extends in a north-south trajectory, separating Sittingbourne from the countryside to the west. So could the officer please confirm whether the location is actually within a countryside gap itself, which was my understanding, and if granted this application, could it potentially lead to a precedent being set for further development in that area? Thank you.
Thank you.
Thank you for the question. No, it's not located within the allocated countryside gap. That's just located to the other side of the road, to the east of the site, so it's not actually within it.
Okay, thank you. We seem to have an issue with the Okay, could we try and address it by turning that up at first? Now, could I invite Councillor Baldock, who probably hasn't got the beeps in his ears as we have to speak on this item?
Thank you, Chairman. No, happily not. Yeah, I just want to say it's rare I go against the parish council's feelings, but I do know that the local resident in the neighbouring listed building actually wrote a letter of support. Thank you, and we should always listen to those most affected. We are really limited in the amount of brownfield that comes forward. It is itself quite a rare resource, and when we've got an opportunity like this, I actually think this is a development proposal that I think fits in with our policies and is the best use of the brownfield site. I'm a little concerned that it's gone from 26 to 16, if what I heard from the officer is correct. I don't think we should be squandering brownfield sites on big, on big houses with little numbers. We need to get affordable housing in the rural areas, and we need to get a quantum of affordable housing on sites that will actually interest a registered provider. So from going to 26 to 16 would actually be less likely to get affordable housing there. So I think this is only outline, but I think we should listen, bear in mind what local people are saying, but also bear in mind the ability to actually provide some affordable housing in a rural area. So on this one occasion, not many, I would urge the planning committee to support the officer's recommendation.
Thank you very much. So I move the officer recommendation. Could I have a seconder, please? Councillor Beard, thank you. And Councillor Beard, do you wish to speak?
I do, Mr. Chairman, and as Councillor Baldock just said, it doesn't do it very often. I don't do this very often, but I agree with what he said. What
very often are a first.
I understand and completely get where the parish council is coming from about closing the gap between Iwade and Bobbin. I drive through here several times a day, and I've always known Hout Green as its own area, and I've always seen it as an area that's, we've got different beeps going on now, that's very much split off from the two villages and is standalone in the middle. I think this is an excellent use of a brownfield site. I commend them for bringing it forward. I do understand why the officers didn't agree with the original application for 26. I think that was trying to fit far too many on the plot. And as the agent said about this site not being big enough for that kind of operation anymore, we've got a similar one on the island that is less than half the size of this, and that too is in the process of being wound down because it's just not economical anymore. And that's going to be industrial use rather than housing because of where it's located. But I think what they've done here, the artist's impressions are always quite nice, but it does give a country feel for a single track off of a main road. I think this is going to fit into the area quite nicely. And I think the imperative thing now on the council will be to ensure that the gap doesn't close any further by allowing the greenfield sites around this to be developed, which obviously they're not in the local plan for development. So I will fully support the officer's recommendation on this good use of a brownfield site.
Thank you very much. Councillor Winkless, please.
Thank you, Chair. I've known this Breakers Yard site for quite some years, and actually it's been an absolute blight on the landscape, which has been touched on by previous speakers. So overall, I feel that the development will be an improvement. So I will be going the officer's recommendations, but I do have some concerns. I think that the ward councillor said just now that if housing goes on this, which is an improvement, it may, hopefully not, open the corridor for further housing on the agricultural land to the east, to the west, and to the south of the proposed development. But in saying that, I will back it, and I also feel that if we turn this down as a brownfield site, we would lose on appeal. So I shall be supporting this one.
Thank you. Councillor Dender, please.
Thank you, Chair. I'll abstain, obviously, because I was out of the room, but I just wanted to make one point. The next to the, on the left hand of the picture there, next to it is the Waller offices, just to the side there. And the Pheasant farmhouse is just past that. Also, I saw on the layout that they're recommending that there's quite a full barrier in the front, yes, of green space. And I just hope that will remain, and that when they come to the final layout, that is not taken away. It's a very nice barrier there with good visibility on the entrance, and also a barrier between the development and the Waller offices. And behind the Waller offices is actually, I think it belongs to Pheasant Farm, is a layout there with other transport. So again, you need a barrier on that. I'm trying to think, it's the southern edge, I think, on the southern edge. You know, got a nice bit of green space barrier. Thanks.
Okay, thank you. Councillor Henderson, please.
Thank you, Mr. Chairman. I think this is really a relatively straightforward decision. The officers propose it for acceptance. We all know that we are needing to find sites, and brownfield sites are always good to find. And I really just want to come on to this question of countryside gap and worrying about what might happen in future. If you've done the planning training, we deal with planning applications on their face value. And somebody said eating more into the countryside gap. The officer has just confirmed to us it's not in the countryside gap. So it doesn't set up any thing that might be used against us later. And it's utilising and rebuilding a pretty tatty brownfield site. So the danger of it spreading in all directions, I'm sorry, it's just not there. We should support this and vote for the proposal and move on, Mr. Chairman.
Thank you. Councillor Bonney.
Thank you. Oh, so if I could just ask the officer a question, because I need to, this is relating to condition 22 on page 126. So I've listened to what everyone's said. You know, I do feel it does sort of straddle, you know, where there's two settlements. However, it's a brownfield site. But my key concern is about contamination, because it's a car breaker's yard. We're talking about using it for residential, potentially. You know, you're going to have kids playing in soil in the garden, etc. So condition 22 says, upon completion of the works identified in the contaminated land assessment and prior to any agreed phase of the development is occupied, a closure report shall be submitted to and approved in writing by the local authority. Well, actually, I don't think that's right. And can the officer tell me, first of all, what a closure report is, and then I'll come back.
Of course, so there's a number of conditions that have been applied to ensure that proper remediation of the land takes place, and those conditions go in a specific order. So the closure report is effectively to confirm that all of the remediation works have been done properly, that we have the correct certificates to show that the land has been remediated in a correct manner, and to really to satisfy both ourselves and the Environment Agency, who would certainly be consulted on such a condition, that the site is now remediated to the point where it's suitable and safe for human occupation effectively.
So I just want to be clear. So in the earlier conditions, we are going to be told about, so when this comes up for the in detail for the properties, we will know exactly where the contamination is on this site. Because what I don't want to find is that this comes before us and we're doing the detail, and then we find that actually there's contamination in a garden where actually it'd have been better building the house foundations over the top to encase it, as it were, and not it leach out.
No, absolutely. It's a key concern to make sure that the site's remediated properly. So condition 19, which is a prior to commencement condition, means that they have to set out preliminary risk assessments where they have to go onto the site and assess it properly and carry out testing to identify any kind of contaminant. We move on to condition 20, which requires verification that any contamination has been removed. And then again, condition 21, if anything additional is found, the development must stop and a new remediation strategy must be carried out to make sure that it's all removed. So there's a number of conditions on there to make sure that at every stage the proper course of action has been taken to make sure the site is suitable.
Okay, so on the preliminary risk assessment, because preliminary one is exactly that, it's normally quite a high level one. At what point do we get a really thorough assessment? Because I suppose I'm thinking about the case in Ashford where the council gave approval on a farm for residential and BSE, where there being BSE livestock, they got approval and then it was judicially reviewed by a resident and that was thrown out because it wasn't considered at the time. So we know this is a breaker's yard. Absolutely want to crawl all over this to make sure, because it should be the polluter pays. So it should be the operation of the breaker's yard that is paying for the cleanup here, presumably. But I just don't want those residents that we then have to represent in 5-10 years' time. So they've got an issue.
No, absolutely. So the first point of condition 19 is the preliminary risk assessment. Then they do the site investigation and they have to provide information of all the receptors that may be affected, including off-site. Number 3 to that condition is the results of the site investigation, and then an options appraisal and remediation strategy to give us full details of the measures that will need to be undertaken to ensure that the site's remediated properly, and then the verification plan demonstrating how it will be, how the remediation strategy will be undertaken. So it's broken down into several phases of the investigation that they have to do, the works they have to do to then mitigate those issues, verification that that will be carried out in accordance with the plan, and then further to that, obviously we have another set of conditions there which provide closure reports to prove that that work's been done. All of those conditions would be subject to consultation with the Environment Agency and with the Environmental Health Team. They'll be checking the details to make sure that the applicant or whoever the developer is complies, and so obviously if they weren't complied with, then we could look into enforcement action.
Thank you.
Thank you very much. And just quickly, Councillor Clark, before we go to the vote on this one.
Yeah, thank you, Chairman. Councillor Bonnie's drilled down into quite a lot of what I was going to say. I am comforted by conditions 19, 20 and 21, etc. In more recent years, breakers have been tightly regulated in the way they dismantle cars and dispose of contaminants and all the rest of it. But I can remember this as a breakers yard when I was a young child, And I'm not going to go into exactly how I
An excellent memory.
but so it's been quite a significant number of years prior to all the EPA regulations, etc., that are in place now. So I welcome the contamination reports that come back to us before the reserve matters. Thank you.
Councillor Martins is desperate to get a word, so I will on this occasion indulge him.
I don't have a hand up earlier. I do apologise. There's just a couple of comments I'd like to make on this. Bobbin Car Breakers is, as car breakers go, quite a well managed site, and as has just been mentioned, goes back well before the 60s. The area, this entire area along here is subject to a bit of commercial usage. You know, there's plant shops, things like this happening. You know, so if this doesn't go to a nice housing development, there's a very real danger that this might end up with a commercial based use, which we wouldn't be able to stop at all. And that's right. When you're talking about the contamination from the sites, that's going to be more asbestos than oil. You know, because the oil, there's actually engine oil is a saleable commodity. So, but it isn't just the buildings, the brake dust, drum dust, it builds up on the surface. But it would be just surface, I think. I'm looking at the housing. To me, the plan is a good mix of diverse housing. It's got a rural impression, and I'm all for it. Thank you.
Thank you. So, members, we'll come to the vote on that one. Those in favour of the officer recommendation to approve. That's 14. Those against and abstentions, just 1. Thank you very much. So permission is granted subject to the issue of the decision notice, members. Thank you very much. Members, I'll just take this opportunity to give us a 5-minute comfort break and to give my ears a rest and try and resolve that issue so that when we come back, we can press on with the business. Thank you. Members of the public, can we reconvene? So members, we'll recommence with item 3.1 if we may please. And this is 21/505/806 full, and it's 114 Lower Road, Faversham. And I thank the officer for introduction outline and any update, please.
Right, hello Chairman, members. Just trying to get this to show you what I think I'm trying to show you. I don't know why it's not showing me that. Blessed thing, isn't it? No. Right, hang on, I might have it. Right. Okay, members, there's some good news and some bad news for you. The good news is I'm doing all the rest of the items tonight, and that may, of course, be the bad news too. So, levity aside, this is the takeaway in question tonight, the one in the middle of this photograph. I've got a couple of other photographs which essentially demonstrate or show you that the surroundings are very residential. You've got housing opposite and to both sides. In this manner, and if you look at the area as a whole, you'll find that it's essentially, this is the building in the middle here, where I'm trying to circle with my little pointer, right in the centre of the screen. It's got this large building, and the surroundings here are, as you can see, entirely residential. I don't think there's any other commercial premises apart from those two in the photograph that you can see on that shot. So the application is to increase the opening hours on this takeaway beyond the 9 o'clock original approval. You'll see in the report at 6.3 to 6.5, there's various suggestions being made by environmental health, but they all come with a caveat that requires investment in improved odour extraction facilities. And there's a question mark about whether the applicant would be prepared to spend the required sums just for a minor increase in hours. And there doesn't seem to be an agreement on that one. Notwithstanding the possibility that we've been exploring opportunities along those lines since the application came in. You see it's a bit over time because in theory this application should have been dealt with by Christmas, but we've tried to explore opportunities elsewhere. But ultimately we've come down to the conclusion that going beyond 9 o'clock opening hours in a residential area like this is not something the council basically ever done, normally does or should do. And that's backed up by the appeal decision quotes we've put in the report. They both relate to certain premises in Milton Regis, but that's only because that's a similar situation where that is a fairly isolated takeaway, albeit with a couple of premises nearby. But essentially it's a very similar setup, and inspectors on that particular case have consistently said 9 o'clock is the best time to be closing, and the reasons they've set out in our paragraphs 8.6 to 8.7 are, I think, as valid today as the day they were written. And think these things don't really change. You can do what you like with extraction systems and things, but you can't really control customers and doors slamming, cars pulling up. And in a residential area, we think that 9 o'clock has always been something the councils try to adhere to. We're not in a local shopping parade even here, and we're certainly not in a town centre. So our recommendation is that we don't think there's any circumstances which we can, with hand on heart, recommend to you that you go along with extending the opening hours or here beyond 9 o'clock. Thank you, Chairman.
Thank you very much. Could I then at this stage please ask Mr. Mustafa Jabarelli to speak on this item, please?
Good evening all. Thank you for listening to my applications. 114 Lower Road is my first business. I have put a lot of hard work and money into it. Currently, the business is very quiet, and I have received a lot of inquiry from local residents for the shop to open later. It's recommended by them because people don't get home until late from work, and when they get home, they want to order food, and we are already closed. When we shut at 9 p.m., we are about to leave the shop. The phone constantly ringing. People are asking for delivery and collections. I have refused their request as the shop is already closed. There is business to be made, and I have obliged to serve the local community for the demand. As we can see, there is no complaint as I have received 24 signatures from the public to keep the shop open later. There's the signatures that I received from the local peoples. I'm aware there was an environmental officer concerned that the vehicle might make a loud noisy after 9 p.m. To overcome this, I will use electric scooter between the hours from 9 p.m. to 11 a.m. Thank you for listening.
Thank you very much. I now move the officer recommendation. Could I have a seconder, please? Councillor Carnell, thank you. And I've now got Councillor Jackson, please.
Yes, I see Faversham Town fully support this. I live in the road and I actually don't think it will be detrimental to noise. And I think we should be supporting small businesses. And I do know a lot of people in the area do use this shop at all times of the day, and they would appreciate it being open later. Thank you.
Thank you. Councillor Clark, please.
Thank you, Chairman. I'm a little bit confused, actually, from Mr. Thomas's explanation. We had a similar application, and there is another application from another takeaway shop in my ward. The one last month was deferred for enforcement reasons for a different thing, but I'm a little bit confused with what is different between this one opening for an extra hour or two in the evening and what the recommendation for the one in my ward last month was for approval. There is a parade of shops with accommodation and residential all the way round the Chaucer Road site in my ward. Perhaps Mr. Thomas could explain what's the differences between Chaucer Road in Sittingbourne and Lower Road in Faversham. Thank you.
Chairman, I think there's a vast difference between the Chaucer Road shopping parade, where there are two rows of shops facing each other with two rows of parking spaces. I think you can't mistake the fact you're in a semi-commercial area there. There are a dozen shops there, I think, and two or three of which are takeaways. This is a single premises split in two in an otherwise entirely residential area. I think it's. I did say to you earlier, this is a residential. It's not a local shopping parade, where I think we would normally go later. My understanding is we have a general rule of thumb: 9 o'clock in a residential area, 10 o'clock in a shopping parade, and whatever in the town centre. And this is not a local shopping parade, which Chaucer Road, I think I know it very well, clearly is. I don't see any similarities at all.
Okay, thank you. Councillor Dender, please.
Thank you, Mr. Chairman. I see a lot of differences, I must agree with the officer. I see a lot of differences between Chaucer Road and this. I live just around the corner from Chaucer Road and use it very often, so I do know it very, very well. It is a parade of shops. If you take a flat there, you would expect there's going to be noise because of all those shops there. The fish and chip shop, Indian, Chinese, and so on and so forth. But here, there are two flats, I think 2 flats above there. And I don't think you would expect to have to put up with all the noise. The applicant just said, after 9 o'clock, the phone keeps ringing all the time. Well, if I was in that flat, I'd get really frustrated if it keeps ringing. And I'd certainly be a lot more frustrated if I had lots of youths or people outside that shop floor after 9 o'clock, 10 o'clock, 11 o'clock. And as the officer said, slamming doors and noise of the cars and so on, I think in a residential area like that, it's not appropriate. So I will be with the officer's recommendation. Thank you.
Thank you. Councillor Winkler, please.
Thank you, Chair. Councillor Dender's more or less touched on what my concerns would be if we was to accept this. It's not really fair for people that are living above the premises. And also another concern of mine would be if we was to go against the officer's recommendation on this, partly what Councillor Clark touched on, that's a slightly different aspect, is that we could be opening a precedence for future applications of the same. And if this one was passed, then we may have difficulty in refusing others. So I shall be going with the officer on this one. Thank you.
Thank you. Councillor Henderson, please.
Yeah, just to pick up a small point, I think I'm right in saying that it's not really the flats above the shop which are the problem, because I believe that the flats above the shop are part of the shop premises, and it's the people that work in the shop and the takeaway that live in those flats. It's the fact that it is entirely residential area all around it, and if there are to be problems, I suspect there will be more a matter of cars and car engines and car doors and that sort of noise, rather than just people going in and out of the shop. Thank you.
Thank you. Councillor Burt, please.
Yeah, thank you, Mr. Chairman. I'm a bit confused why this one's before us to begin with, because it's here because of a Faversham Town Council representation. The representation says members agreed to support the local business. Well, I thought they could only call it in if it was a material consideration. I don't see that that is a material consideration, personally. I don't know this area very well, so I bow to the knowledge of the ward member, but I've just had a quick look online, and the shop next door's opening hours are until 10 p.m. So the shop next door has already got an hour more than the takeaway has. So the argument about slamming doors and people hanging around outside, that's going to happen up till 10 p.m. anyway, because the convenience store that presumably, I haven't looked, but I'm assuming they sell alcohol.
They do. That's my question.
So that will be open till 10 p.m. anyway. I do that. There's been one representation received, and it doesn't actually list it as an objection. It says that they've raised concerns about the later opening hours could result in antisocial behaviour. I'm minded to go with the ward member on this and overturn the officer's recommendation, because I actually think this isn't that detrimental to the area to extend it. I mean, if they came to us asking to open till 10 p.m, the same hours as the shop, I think we'd be in a very different position. But I'm happy to actually support this.
Thank you. Just to confirm that Councillor Jackson's in the adjacent ward rather than as opposed to the ward member, but obviously you flagged the speed. Thank you. Yeah, Councillor Hall, please.
Looking at 6.3, where it does say you'd be agreed to have the weekend from 10 o'clock. Can you tell me, really, why can you tolerate that at the weekend and not from midweek? The other thing is like to add is I'll support at 10 o'clock. Mr. Thomas?
Well, I think it's traditional to expect premises to be open later on Fridays and Saturdays. It's the days of the week when most people in 9-to-5 jobs haven't got to go to work the next day, and where most clubs, pubs and social facilities tend to be open later hours, as you'll be familiar. So I think the environmental health officer was saying that might be something which might be either expected or more normal than less normal. And so you haven't got let's say late night open on a school night when people are going to get up in the morning. But that was just his suggestion, and that was caveated with the applicant having to invest in upgrading the extraction equipment for simply 2 hours a week, which I think no one's in their right mind would want to spend a considerable amount of money upgrading their equipment just for 2 hours extra trading a week. And just in terms of Councillor Beart's point, I think I think the situation with the shop next door officially is that it's a shop, been there for donkey's years and it hasn't got any planning hours on it. It's just it can open when it chooses to. It could open at 2 o'clock in the morning if it wanted to, but it doesn't. I think on most of the local websites you look at, it says it's closed at 9. Sometimes it might say 10, but it might vary. I don't think it's very clear, and I don't think we should be making planning decisions based on what other people choose to do randomly, because they could decide to open to 11:30, and then one might say, well, why don't we allow this to open at 11:30? Takeaways, I think, are notoriously different from shops. They're specifically excluded from the shop use class for very specific reasons to do with the nature of the trade and the customers and the activity that happens. A lot of it's happening outside of a lot of activity happens outside a takeaway, whereas in a normal shop, pretty much nothing happens outside a normal shop other than you walking away with your products. Hanging around, eating outside, congregating doesn't happen in normal shops. So I think there's a difference between takeaways and normal shops, and there's every reason not to just accede to whatever happens next door because that happens next door without any planning control. So it's a decision for members, obviously, but we don't have to be guided by whatever happens next door.
Sorry, could you speak to Mike?
Yeah, but what evidence have you got that this wouldn't work? This extra?
I don't suggest an extra hour. I suggest 9 o'clock is the right time to close in this sort of area.
That's your suggestion. That's what I'm saying. But there's no evidence to say that closing at 11 o'clock would be detrimental.
Well, we've got 2 inspectors' planning decisions quoted in this report on a very, very similar situation. This site, I know this site very well. I know the one in Milton Regis very well. Councillor Winkless knows the one in Milton Regis very well. And I think what we're saying is this is the closest parallel. We've already, I think, discussed the fact that Chaucer Road isn't a close parallel, or not in my view anyway, and Councillor Dendell agrees with that one. So I think what we're arguing is it's a simple common sense situation. Do you, as common sense, intelligent people who know quite a lot of stuff, think going beyond 9 o'clock at night in a residential area is a good thing or a bad thing? And it's a simple decision for you to make.
Yeah, but there's nobody complained about this at all.
I'm not sure that is ever a factor which should be indicative of our decision, is it?
Oh, I thought noise was a form of complaint. I thought it was
yeah, of course. Well, but we're quoting the report that the Environmental Health was does say there have been complaints.
What?
But there's no complaints on this application. Don't get me wrong.
Well, would we be happy to offer 1 hour from Monday to Sunday?
Yeah, the issue is it's not what's been proposed here on.
Well, it's often it for the weekend, isn't
So,
it? Saturday and Sunday.
Okay.
Chairman, if the applicant had asked for X and we thought Y was appropriate, we could recommend Y. But our view, I mean, this is a simple situation.
Yeah, I get that,
I
Mr.
don't
Thomas. I think
we're
I'm going to have to.
recommending
We'll
there's
curtail
no
it and move
extension.
on.
If there was, we would have recommended it.
Yeah. Okay.
But it's up to your members, obviously.
Thank you. Councillor Hampshire, please.
Thank you, Chairman. I wasn't actually going to speak on this item, and I'm not really going to make any comment other than just what the officer has said about the ability of a business unit to choose its opening hours. He was talking about the shop next door, and they could choose to be open till 2 o'clock in the morning if they so wish. Equally, they could choose to close at 7 o'clock. Now, just because this business has applied for an 11 o'clock, to an 11 o'clock extension, does not mean to say that that business will operate till 11 o'clock. Some people look at the footfall that goes on and goes, you know what, it's not worth me staying open. I'll close at 9:30. So I actually think what the officer has said is disingenuous to the applicant, because what suits one can't suit him. And I actually think he should apologise for that remark. That's the only thing I was going to say, and I'd like to go to the vote, please.
Okay, Councillor Fowle, did you want to? It was answered. Thank you. Thank you. Okay, members, so those in favour of the officer recommendation for refusal, please. No. Those against the officer recommendation for refusal? And abstentions? So the motion to refuse has been lost. 9-4. Sorry, 4 for the refusal, 9 against refusal, and 2 abstentions. So members will now need from the floor a counter proposal. Councillor Beard, please.
I propose that we approve the application and defer to officers to word the conditions, the standard conditions that we would apply.
Thank you. Seconded by Councillor Jackson. All those in favour? Those against?
Chairman, can I ask what that means? Because, I mean, standard conditions, there are no standard conditions for takeaways. I mean, it's an hours. I mean, there hasn't been a proposal. I'm really not trying to be difficult here, don't get me wrong. Councillor Bitt proposed that we approve it with, I think he said standard conditions, but I said there are no standard conditions. He didn't propose what hours you would be wanting us to impose as the condition, whether it's 9:30, 10 o'clock, 11 o'clock, or which days of the week you might be talking about. So I'm not sure that what you voted for, with the greatest of respect, means anything to me at all, other than you're quite happy.
Okay, well, I misunderstood
so
that too then.
Please, if you could. Yeah.
Mr. Thomas, with due respect, I misunderstood. I thought earlier you spoke about a standard policy for opening and closing hours. So that's, I'm assuming that's where Councillor Beard came from. So. Sorry.
Well, with the greatest respect, when a member suggested, could we suggest 10? We were told, and they've applied for X, we can't give them Y. So why are we now being asked? Surely we're approving what they've applied for.
Oh, I see. Sorry. So what you're so thank you, Councillor Bitt. So you're suggesting that I think you're being quite clear now. And I'm grateful to you. You're suggesting that if we approve the 10 o'clock on Fridays and Saturdays, which is what they asked for, isn't it? Isn't it?
Yes, as per
11
the
o'clock. Sorry, hold on. Let me come on a second.
Yes, it's 11 o'clock. Yeah.
Okay. Right. No, I'm happy to look through that again and go with what you're suggesting. Thank you very much.
Thank you. Councillor Martington, yeah.
Can we put the condition in about the improvement to the silencing, please, on the extractors?
Yeah.
Are you voting for that too?
Do you want to go to the formal vote for that, or just append it as it is?
I'm happy to accept it as an appendix to my.
Thank you. And Councillor Jackson, a second, are you? Yeah, thank you. Councillor Henderson, please.
I think you initially started to count votes there, but can I be clear? We need to vote now that we know we are voting.
Right, okay. All the week, that's it, that's fine. Yes, okay, thank you. Right, so those in favour of that proposal? With the added condition, of course.
Right, against.
And those against?
2. Yeah.
And abstentions, please.
Okay. Right.
12 for, 2 against, and 1 abstention. Thank you, members. So that application is passed subject to issue of the decision notice. Sorry. Yeah. Does the applicant understand what's just happened? Are you aware you've got the permissions subject to the issue of the decision? Thank you. Now we move on to item 3.2, please, members. And this one is 21/505/951 and it's Gilron, Bell Farm Lane, Minster-on-Sea, ME12 4JA. And I thank Officer for an outline and any update, please.
Right. Thank you. Sorry for any confusion on that last one, members. I really wasn't trying to be difficult. I just didn't quite understand what you meant. Right. This one, as you'll know, relates to the further enlargement of what was originally a small bungalow, and just to demonstrate what we're saying to you here is that this is the plans we have of the bungalow that was submitted to us in 1999 when an extension was proposed. You'll see it's well, remarkably small, I suppose, is an easy way to say it. What we approved in 1999, and I have to say I was somewhat involved in this decision, so I was very young at the time, but we approved an enlargement, and you can see on this plan here that the entire area to the left of the lower part is an enlargement. So that's a reasonably modest enlargement of the dwelling there, but it substantially improves the situation compared to what is on the left. So on this one screen, you've got the property as it was and the property as it was approved to be. So that's all in line with the policies we were operating since 1993 or before. But then by the time it got to 2011, the application probably stood like this. So you'll still recognise that as a fairly modest bungalow, not quite as we approved it in 1999, but of a similar scale, and a similar extension has been carried out, maybe not quite in accordance with the plans, but still a modest bungalow. And if you particularly take notice of this single-storey rear extension on the back, which is described as a conservatory on the plan, which I'm just circling now, because that's a point which you can recognise in a moment when I come on to the proposed plans. And what we approved in 2011 was, this is the rear bit I was just mentioning to you. What we approved in 2011 is all this bit down the side, which is described as a two-storey extension in the sense that it's got a bedroom within the roof. And you'll notice that the front is still fairly plain, the back has got some roof lights, and it's got this dormer window which lights that bedroom in the two-storey extension. So the right-hand part of this bungalow is the 2011 extension. The very left-hand part is the 1991 one, and the only bit that's original is somewhere in the middle there. So that's where we were, and that we think is a result of a double extension, one side and the other. But that was approved in 2011. What we're being asked to approve now is going from the existing elevations, which is like this. Well, notice the conservatory, which has never had planning application on it, but it's there anyway. This is not the dormer window that you just saw on the approved plan. It's actually a large set of patio doors with a large flat roof on top of it. So that's not been built according to the plans, and nor have these two dormer windows here. Well, dormer windows, double dormer doors, you might call them, with balconettes, and this balcony on top of that little single-storey flat roof part I asked you to take a note of earlier on, which is this part here. So this is how the property stood before the application was made, even though these dormer doors, this balcony and this dormer are not in accordance with what had ever been approved. But nevertheless, that's what it stood like. So we've got an application for this, which is to keep all those dormer doors and patio doors and to keep this terrace, but also to build on either side of this single-storey rear projection. So if I go to the floor plan, what we call the existing ground floor plan as of before the application was the bungalow as extended on both sides. You saw that the conservatories here, the road's at the top of the page, and this is the single-storey bit on the back that I asked you to keep your eye on. But the application plan is for this one, which is for an extension here and here on both sides of that single-storey, bringing it to the same level. So just squaring off both sides, but it also seeks permission for those roof alterations which never had the proper planning permission. So it's a composite application. Part of it's retrospective, and part of it's for these two extensions which have not been built. But it does include the balconies, balcony in plural and singular, if I may say so, which is on top of that single-storey rear extension. Now, in other terms, the photographs from the front, the bungalow looks as you might have expected. It's got the original bungalow plus extension, plus the 2011 extension to the right here. The solar panels are permitted development, so we don't need to worry about those. But the rear elevation facing towards the two-story extension has got, this is not the dormer window I showed you on the approved 2011 plan, but it is a pair of double doors, a balconette, we might call it. This is the balcony on top of the single-story rear extension that's been there a long time. The same applies if you're looking the other direction, the balcony's up there. This is the adjacent bungalow. Well, there's two bungalows on this site, in fact. This one is what you might call the original bungalow, and there's another bungalow further back on the site. This one's vacant at the minute, I understand, but it could be lived in. I think it's a lawful bungalow. But if you were standing at the rear of that bungalow, looking towards our properties, we call it, this is Kentucky. This is the alterations, the two dormers that's been built, and the third dormer plus the balcony. But in terms of the actual view that you would get from the balcony, it's the reverse of this. So if this was your patio, this balcony would be looking straight down onto you, and that's our main concern in Region 2. That this balcony very much invades the privacy at the rear of this lawful bungalow next door, even though the owners at the moment live in another bungalow which is towards the rear of the site, further down. But there's two reasons for refusal. There's the gradual increase in scale, which has now gone beyond where we think is a reasonable limit, and the effect on the next door bungalow, if you were living here, the lack of privacy you'd have from that balcony. That's the generality of this application. Chairman, thank you.
Thank you very much. I'm not going to get our Democratic Service Officer pleased to read out Parish Councillor Dolly White, not Town Council. Minster is a Parish Council, so I'll ask Mr. Atway to read that one out for us, please.
Minster Parish Council found that there were no material planning concerns with this application on the basis of documents provided with the planning application. Thank you for your consideration.
Very helpful, thank you. And could I now invite Peter Lay, please, to speak on this item?
Thank you. Before I start speaking, there's 2 points this gentleman's got wrong before we start. If that's okay, can I address them, please? If it's okay.
Go on.
Yeah, the building that you see there to the far is not my property, doesn't belong to me, and it's been condemned by the council, been emptied for many, many years. The second thing was, if you go back a couple of slides where I put the new doors in, he said about a flat roof. It was actually given permission when I put that extension permission in. The roof was already there. He said to me, the gentleman said that it hadn't been approved, and it had. So he's got 2 facts wrong to start off with. Can I just point that out, please?
Thank you.
Okay. Yeah. The
You're going to start your.
Yes. Sorry. Yes. Yeah, we're asking permission for just 3 walls to be built to make 2 extra rooms in our house. The two of the walls that we're asking for will have doors in. So realistically, we're asking for a 1.5 walls to be built. Yes, it will make our house a little bit bigger. We have got 2 family members coming to live with us soon. One of them is old. He's 83 years old. He's got Alzheimer's. And he's got a 53-year-old son who's got learning disabilities. My wife's brother. We are extending our obviously front room. We're going to be extending the hopefully making a toilet. And then when my father-in-law passed away, he will physically come and live with us permanently. So my brother-in-law. I'm trying to think about what to say. Sorry, I've completely forgot what I was going to say. Sorry.
That's okay. Take a second.
I asked my previous neighbours 4 years ago if he objected to the balconies being done. He hadn't had no options, no problems whatsoever. We started the building work. Within a year, he sadly passed away. The property was then emptied for 18 months until my new neighbour moved in. They then asked permission for an extension on the side of their house. They got that. We then submitted our plans for this, and then she objected 8 months after her plans were already in. Her extension comes closer to our house, so she's looking closer to us. I can physically see from my front room and my dining room, her entire garden. I am in a rural area. I look over the middle of nowhere apart from fields, and I see the sea. I took advantage, obviously, for the door. The door was the patio doors already had a dormer window there, so I took that out and just carried on down with the building to make a small little patio. My son's room at the end there that had a escape window, which was very, very large. We just took that out and put a small little dormer on, and for safety, if there was any fire in the house, he could get out of the room very safely. We walked onto the balcony just for the nice views that we have in our back garden, because we do live on the middle of nowhere. So, Jason, that building is not mine, so I do not consider that being part of my plans. So I'm asking for the extension just for help my house and my family grow.
Thank you very much. I now move the officer recommendation. Can I have a seconder, please? Councillor Dender, thank you. Members, anybody? Councillor Winkler.
Thank you, Chair. I've listened to the officer's report on this and also what the applicant has said. I feel that I will have to go with the officer on this one because from what I can see, if we go against this, there will be quite considerable overlooking to the neighbour next door. And also, as I'll say many times on these applications, it could set a precedence for others. So I feel I will have to go with the officer on this one.
Thank you. Councillor Dender, please.
Thank you, Mr. Chairman. A couple of questions actually for the officer, if I may, both on material considerations. One is, if I remember the figure correctly from the report, from the original cottage, this now makes 240% increase. And that my first question is that a proper material planning consideration? And then the second one, on the report, I heard the applicant mention an objection, but there is no objection in the report. Maybe you could clarify that. Have we had an objection from the neighbour or not? Thanks.
Thank you. Mr. Thomas.
Right, thank you, Chairman. Yes, I think the first question, the fact that the application probably has been extended by an enormous amount is a material planning consideration. The number itself is not particularly important, the number specifically, the mathematics, but it's indicative of the fact that the local plan, the adopted local plan, talks about modest extensions to properties in the rural area. Our supplementary planning guidance, which is allied to the local plan referred to therein, refers to a 60% increase in floor space as the normal limit to where we might see modesty, and that's occasionally gone over. The original property here was so small that I think a bit of leeway would have been acceptable, and we've approved applications on both sides, as you saw. But it is a material planning consideration. It is tied to the local plan, and therefore is tied to the development plan, and it is entirely proper for you to be able to consider that. The second question, I think, again, you're entirely correct. As far as we can tell, the neighbour has not objected to this application, full stop, even though Mr. Lay said that they had.
Thank you very much. Councillor Henderson, please.
Yes, Councillor Dendo's picked up this point about a reasonable extension. I had an example in my own ward, which I think put forward 4 planning applications such that it was about 250% the size it started out, and it's now totally out of kilter with the rest of the area. But I do think the question of overlooking is more important, and I'd like to clarify the point which the applicant made, saying that our officer was wrong in saying that he didn't have planning application I thought you said you didn't have planning application for that dormer window, whereas I gathered that the applicant was saying that he did have planning consent for the flat roof. Can you clarify that for me?
Well, I'm not sure I can really, but I don't think there's any real confusion here, to be honest with you. What we approved in 2011, which I showed you earlier, it shows a pitched roof dormer at the rear of the new extension, which is now a flat roof dormer and double doors, but that's not quite the point. There was a dormer window proposed there, but the rear, the bit at the back, the bit I asked you to keep your eye at the beginning, has and always has been, as far as I can see, a flat roofed extension. There's no bones about that. It was approved as a, well, I don't think it's ever been approved. It's just been on some plans, but we've always considered to be a flat roof extension, and there's no doubt about that. All that's happened here, I think, is that the applicants put some balcony railings on it because it's a flat roof, and we're not saying it shouldn't be a flat roof or it should be a flat roof. It just is a flat roof and always has been.
Sorry, could you?
The planning consent was for a pitched roof dormer. There is not planning consent for a flat roof dormer with double doors in it.
Well, no, that never has been, no.
No, okay. Well,
Could you press it? Okay, thank you, Councillor Henderson. Councillor Fowle, please.
Thank you, Chairman. A couple of points. The 200% increase, it was a really modest bungalow, but you look at the Google Maps and the other houses along there, and it's not a dissimilar size to the others that are along there anyway. And you go around Bell Farm Lane, they all look of a similar size. And, you know, modern needs, people need bigger houses. But what it doesn't show is this site's on quite a gradient, because I walk my dog around there. So the bungalow that's been built alongside their property, they overlook their whole garden, I believe. The bungalow's a bit further down the site. It really does tail off down there. It's quite a hill, so you're always going to overlook someone.
Okay, thank you. Councillor Bate, please.
Yeah, thank you, Chairman. What was obviously there originally is what most of the sites along Bell Farm Lane had originally were light construction prefabs, and some of them are still existing, and the resident or the applicant made mention of the one next door having been emptied for a long time, and I think there's a number of them along there that are empty and beyond repair. I've got some questions for clarity in terms of consistency with the application of DM11, because it mentions in the report at 8.3 that the previous additions added 102 square metres to the original floor space, and this would represent an increase of roughly 204%. And then, so my first question would be, why wasn't DM11 applied then? And I take the point, and I don't know whether Mr. Thomas said lawful or awful when he said about the previous bungalow, but I would say it's probably both, because that size of property would never be acceptable in the current circumstances. But we've now got this application for an extra 18.7 square metres, which would take it up to 241% of the original floor space. And I don't disagree that is significantly exceeds the 60% adopted guidance. However, I know of applications that have been approved under delegated powers where schemes have gone far beyond that. And I've got one in front of me here with DM11 being applied. And it says, in this instance, the starting point for consideration is that the property as existing is already well over the 60% threshold, as the above replacement dwelling and various extensions amount to an increase of, and this was over the floor space of the previous, it was 360% in that case. I am therefore firmly of the opinion that the objectives of DM11 and the SPG in respect of modest extensions has already been exceeded here, and the intent of the guidance has long since been made irrelevant. I consider that refusing the proposed extension on the principle of a modest 60% extension would, in this instance, be unjustifiable and unreasonable. That horse has already bolted. Now, that was written by one of our officers. Now, I would say that if we're already at 204% and they're adding it to 241, the horse has already bolted. We're way above the 60%. And I just wonder where we draw the line of when we apply DM11 and when we don't. So that, for me, the extension bit isn't the contentious issue. What I do have grave concerns over is the balcony and the overlooking. Whilst I do respect that the bungalow next door is currently empty, that plot of land is still a habitable plot of land. There is still the second bungalow in the back garden, and that site could have a house built on it, and that would be their amenity space. So I do have concerns about that, but I do think the reasons being put forward don't quite add up, and they're inconsistent with some of the decisions we've made previously. And when I say us, I mean the council, because what I just read was a delegated decision, not this committee.
Okay, thank you. Mr. Thomas, did you want to comment?
Well, I don't know which case you're referring to in the quote you make, but I've been doing this job for 35 years, and we've applied the 60% fairly consistently as officers. Now, there may have been occasions where a very small property has, as I said before, on this particular case, been seen to be an exception where if you start with something very small, 60% is still very small, and it still doesn't make it habitable if it was so small to be uninhabitable. But with great care, I suggest that there are a number of decisions that I'm aware of where members have overridden our recommendation to refuse large extensions, and I can think of one on the Lower Road in particular, on Brambledown Way in particular, where that property has been extended beyond all recognition, and it may well be that in a case like that where someone comes along for a further extension, we essentially have thrown our hands up and said, well, it's a bit late to be arguing that now when members have already approved something extraordinary. And you've overturned our recommendation these quite a number of times, I may say so. But I think as officers, we've been pretty consistent where the facts have been the same. But it's also the case where different extensions have different impacts. And an infill extension around the back is one thing compared to another 2 stories, for example. So it's sometimes horses, of course, and I don't mean to be rude to you members, but I don't know the example you talk about, and it may be that it's one that there's a particular reason why you could pick one example where, to be honest with you, day in and day out, we try and apply what local plan says for you.
Okay, thank you. Councillor Bonney, please.
Yeah, I mean, I can think of one in my ward where there has been an enormous increase, and that wasn't down to members. In this instance, I think I'm not so concerned about the extension. It's at the rear. I don't believe that will create any particular harm to anyone else. It is the balcony, but I'd like to get an understanding. I don't know this site, but it sounds like it might be on a hill. So whether you look out of a window, you're always going to overlook the neighbour's garden looking down a hill. So I need a bit more understanding of that, because are we prepared to allow the extension and it's the balcony? Balconies are always an issue about overlooking and someone's privacy. But quite honestly, if it's on a hill and you look out the window and you're going to look in someone's garden, I really can't see that so much of an issue.
Yeah, could you, Mr. Thomas?
Yeah, yes, I fully understand that point. I mean, obviously, people's gardens go up and they go down. But when you look out of a window which faces directly down your garden from a rear wall, which is like parallel to the road in simple terms, your field of vision is down your garden. You can see your neighbour's vegetable patch. You can see their garden. You can see them at the bottom of the garden. What you don't see, really generally, is them on their patio in the first metre or two behind their rear door, where they might choose to have a social occasion or to breakfast outside or something. You don't generally see that immediate view to the rear. So to see most of people's gardens is quite normal. I can see most of my neighbours' gardens, but what I can't generally see is the bit right behind their kitchen door or their patio door. And in this particular case, the problem with balconies, it says it in 4.2, that the guidance which we've had around for, I think, 30 years next year, that guide to be written down for 30 years. The problem is you've got this oblique view from the balcony straight down and almost into the rear windows of the neighbours, which is the reverse view of that view I showed you a minute ago. It's that view which I think Councillor Beart's explaining himself, that if you were trying to have a private conversation where my cursor is on this grass here, which might be a patio. Anyone on that balcony there would, be able to see straight down on you, whereas you wouldn't be able to see them if they were looking out of their rear windows. That's the issue, really.
Sounds like a strategic tree is needed, quite honestly, to sort that out, which it could be conditioned with that there is landscaping to mitigate that.
Okay, thank you. Councillor Hampshire, please.
Thank you, Chairman. Absolute poppycock. You should come and look out the back windows of my house, okay, and you can see the patios of my neighbours either side. Absolute poppycock.
Perhaps you need to move. Councillor Fowle, please.
Button again. Oh yeah, I mean, my neighbour has a balcony that looks straight into our back garden, but surely, and what they've done is put a small privacy screen down the sides to contain the view going straight. So could we not do something like that? Have a privacy screen on the side?
Councillor Dendorf, then Councillor Beard, and then we'll move to the vote.
Yes, and it's just to back up Councillor Fowle there, because I do remember some time ago, I don't know if anybody else remembers, we did actually do that. We put a condition on of a privacy screen on a balcony. I don't recall what application it was, but I do know we did that. Yeah.
Councillor Beard.
I recall that application very well, and the applicant was an officer of this council. But we put in a condition that they had to put privacy screens down the side so they could only see out forward, so they couldn't overlook the neighbours. Now, I think that's I think looking at that photo there shows the concerns that the officers have and the concerns that I have about overlooking. And I think that Mr. Thomas has got that right. But I think there is possibly a way that you could put a privacy screen there so they are only looking down across the field rather than into the neighbour's garden. And I think if that's something that could be considered, I might be minded to actually support this.
Chairman, can I
yes, Mr. Thomas.
I think the thoughts of members are very wise, but we're dealing with an application which doesn't have a privacy screen on it. I think we need to. If I were you, I'd just urge you to deal with this application as it stands. If this is refused, and the applicants are perfectly entitled to make another application with a privacy screen, and he might come up with a plan which solves the problems, and they might be able to consider the whole thing again, rather than wish for an application which isn't with you. We're not meant to try and wish for the application to be different. We determine it as it stands, and then they can come back with an amended scheme if they want to. I think that would be a better way to deal with it than to do it like that. We can condition it if it's on the plan to be made sure it goes in, but I think to require one to be built, I think that's a difficult condition to word rather than to condition something that's already on the plan.
Okay, thank you. Right, members, we'll take this one to the vote then. Those in favour of the officer recommendation for refusal? Those against the officer recommendation for refusal? And abstentions? So it's 10 for refusal, 2 against and 3 abstentions. So permission is refused, subject to the issue of the decision notice. Members, we now move back then to item 2.1, please. And this one is 22/500014 and it's Moons of Selling. Moons of Selling Limited, Grove Road Selling, Faversham. And I think that was for an update and an outline of the updates.
Right, members, I'm very pleased to say that this is a rare example of a brownfield site in a rural location. In fact, within the Kent Downs area of outstanding natural beauty, it's this site at the bottom of the picture here, which has got a lawful development certificate for haulage and civil engineering vehicles and storage of plant and equipment. And it's very much out by Perrywood in one of the most remote and idyllic parts of the borough. We granted planning permission in 2015 for 5 houses on this site as a way of reusing it. Those 4 of those houses are well underway. In fact, I've got some photographs of them. This is the actual site we're looking at tonight, the one that hasn't been built on yet. But then further down the page here, you'll see that the other 4 houses are well under construction. They've all share a similar ilk, with the pitched roofs and the dormer windows, that sort of style. They're all large detached houses with 4 or 5 bedrooms and double garages. It does keep the numbers down on the fact that the roads there are extraordinarily narrow. But what we approved in 2015 was this design. It's fairly pleasant. But what we're being asked to approve now is this design. It comes up. Bear with me. Which I think is certainly more colourful, but I think equally pleasant, if not slightly more so. The main reason this is with you, of course, is the Parish Council's comment. The difference between the approved site layout, which is this one. So we're looking at. Let me make this a bit bigger. Perhaps not that big. Yeah. So if you focus on the bit of the site that matters here, we're looking at this plot here, plot 5, and this is Barn House, which is an established dwelling with a back garden in this general direction. So at the moment, this plot 5 is facing slightly to the southeast, with the rear windows facing slightly to the northwest, if you might say so. Perhaps that doesn't particularly look towards Barn House very much. The layout we're being asked to approve now is this, where the building, you can see if you've got really eagle eyes, that the red dotted outline, perhaps you can't see it very well. I can barely see it from here, and I'm only 6 inches away from the screen. So you can see a red dotted outline here. Anyway, so basically we're turning the thing by 20 degrees or so that it faces slightly to the east rather than to the southeast. None of it means that these rear windows face more towards the private rear garden of Barn House. And as you'll see, the Parish Council seems to be slightly isolated in its objection to this, whereas everyone else seems to think it's a jolly good idea. So no updates other than just a description for you, Chairman. Thank you.
Thank you. I move the officer recommendation. Could I have a seconder, please? Councillor Dender, please. Thank you. Councillor Winkles.
Thank you, Chair. I've just been looking at local representations, and as I think as the officer just touched on just now, nobody is against this. In actual fact, they're all in favour of it. So I can't see any reason to not go the officer. That's what I've got to say on this one. Thank you.
Thank you. Members, anybody else? I don't see anybody else indicating, so we'll take this one to the vote. Those in favour of the officer recommendation for approval? Members, that's unanimous, so permission is granted subject to issue of the decision notice. We now move on to item 2.2. And this one is 21/506308/ADV. And I thank the officer for an outline and an update, please.
Yes, thank you, Chairman. This is an application for some temporary 12-month advertising signs for the development we call Wises Lane or Southwest Sittingbourne, which, as you know, is approved on appeal. We'll move past on that one. But Wises Lane comes down from the A2 at the Grove here. And as you pass the roundabout, which gives you access to Maynham Gardens, these advertising signs will be up on the bank on your right as you go southwards towards Borden. They are one V board, sorry, 2 signs back to back, basically, and 2 flags either side. So a symmetrical layout, and it would look like this. The board here high enough to clear the hedge on the legs. That's two boards here back to back, and 2 flags to 6 metres in height. The name on the flags is something which the Parish Council have commented on, but as you'll remember from when we had a similar application at Stones Farm, where the developer decided to call it Spring Acres, that was in Backyard. The content of the advert is not our concern. That advertising application could only deal with on the grounds of public safety and amenity, not whether we like the name or not. So we need to look at the contents in terms of visual impact or maybe noise impact, according to the parish council, because they raised concern about that in terms of the flags making a noise. But this is well within the developed framework. If we look at what's proposed for the site, we're looking at a location. If you can see it at all, I'm going to use my pointer. The position of these flags is right. If you can see where I'm trying to point to now, pretty much right within the middle of where these developments will be. It's not right outside anybody's existing house or in an area which isn't to be developed. It's pretty much dead centre from the overall layout. I think it's intended to advertise this first tranche of housing to the north west of the roundabout, basically. Thank you, Chairman.
Thank you very much. Could I invite Councillor Mike Baldock, please, to speak on this one?
Thank you, Chairman. I don't know if the other ward member wanted to speak first, as he's a member of the committee.
He is on the committee, and I will afford him that should he wish.
Well, it is customary for me to speak first, but you know, I'll let Mike speak.
Thanks, Nick.
Thank you. Yeah, I think it's appreciated that the applicants have changed the name. They have listened to local people. I know, you know, the officer said it isn't a planning application, but it is to be welcomed. I personally don't, you know, Applegate there is a local butcher's called Applegate, but the idea of cherry orchards is still a bit close to cherry fields. Personally, I suggested Plumstones, but that didn't go down well. So I think it's, and the fact they've reduced the amount of signage is welcome. Personally, I'd rather they didn't put it up. I think it will have you know, a visual impact on a rural scene. As the officer said, it's not near houses. No, because it's in the middle of a view of countryside. But I doubt there would be a winnable appeal on it. But of course, the appeal, if it took 12 months, they'd probably have got the work done by then. So it would the impact on the view would be reduced because we'd have the impact of the houses. I'd like it not to go ahead, but I suspect that there are very limited planning reasons to challenge it. Thank you.
Thank you. Councillor Hampshire, please.
Thank you, Chairman. I mean, to me, this is quite an easy decision, I think, before the committee to make tonight. It's more for formality than anything else. And I think it is encouraging that the concerns that have been expressed by the local community have been taken on board by the applicant in terms of reducing the number of signage in place. I do think, though, it's important to remember at the moment, although the outline permission has been approved by the Secretary of State, it's only the 80 that actually has the detailed permission to be built. So this is for the first phase being the 80. There are still further decisions to be taken as to how the rest of the site will come forward, if it were to come forward, because that's in the gift of the developer, isn't it? Just because they got permission doesn't mean to say they're going to do it. But what I would say is there are some concerns that I have, and if the committee is minded to approve, which no doubt it probably will, that actually the name is looked at a bit more closely. Cherryfields is inappropriate because of the road Cherryfields, like 300 yards down from the site. I think Applegate has some issues in terms of reputational issues with other businesses within the ward. So if I could give one piece of advice to the applicant, that they strongly reconsider the name and actually afford the opportunity for the parish council and the ward members and the officers maybe to have, you know, that in mind. And in terms of the flags, you know, there is quite a strong crosswind that goes along there at the moment. So I think they need to maybe think carefully about how those flags are fixed. But really, the parish council and the local community needs to choose the battles it wishes to fight. And this is a battle which I think is the wrong fight to have. And reluctantly, this signage needs to go ahead. The community is not being singled out for this signage. You go wherever you go across the county of Kent or further afield, every single development will have a board, it will have a flag It's just a fact of development. Okay, so I understand the concern that this is going to cause the community, and unfortunately it is a realisation of something that most in the community did not want to see, and something indeed I voted against. But it is about picking what fights you're going to pick, and I think on this one this is the wrong fight. But what I would ask is that the applicant seriously consider the name of the development, and if there is a way of having a condition put in place, if you were to approve, to say that there be further dialogue between officers, the parish council and the ward members, that would be gratefully received. Thank you.
Thank you very much. And on this point, I'll move the officer recommendation. And could I have a seconder, please? Councillor Dendar, and you wish to speak?
Yes, very briefly. I thought we said right at the beginning that the name is not a planning consideration.
We did.
We cannot ask the officers to enforce a name. They have, I believe, gently talked to, and the name has been changed once, but of course there's no enforcement powers from the officers on this, as it is not a planning consideration.
Thank you. Councillor Bonney.
Can I just ask, that man, is he true to size compared to the sign?
Well, the poles are 3 metres to the bottom of the sign. So if that man was 2 metres tall or 6'6", it'd be roughly the scale, yeah.
Okay. It's all right, it's not going to decapitate anyone, that's fine.
Yeah. Okay. So members, I don't see anybody else indicating. Those in favour of the officer recommendation? That's unanimous. So that's good, members. Thank you. And yes, we do miss the Hollywood sign, as described by Councillor Beard as the underwhelming Hollywood sign. Members, we now move on to item 2.4 then. I'll just let Councillor Bonney escape. I'll call you whatever you want me to. Yes, go on, go. So this one is 22/500563 and it's a St Michael's Church, High Street, Sittingbourne. And I'll thank the officer for an outline and any updates, please.
Actually, this is a Grade 2 style listed church. It's a pretty important building. It's in the conservation area. The railings obviously disappeared in the war. This is a restoration project to put the railings back on top. It's a very simple railing. Some of you will remember it, no doubt, but not me, obviously. You know, I'm blimey.
Really?
What are you suggesting? So again, the railing's missing, but we've got a plan of what they want to put back. This is a council application, by the way, so that's why it's here. It's principally, as you said, there's no rejections to this application by anybody, but it is from the Borough Council, so it's being put to you rather than being dealt with on the QT. It's a very simple railing with a scroll at either end where it meets the piers and a scroll partway along the elevation. I think there's a better plan which gives a bit more context for you. I think that shows you the general. So it's the bit at the top here which you're being asked to put back. Most of the rest is already there, apart from some obviously rebuilding where the wall needs rebuilding. It needs a good look after. And we've got a brand new plan sent in yesterday just to indicate that what the section through the wall is. But that does not, in our view, completely cover all the issues which might be necessary for us to keep a very close eye on with this building. So we have tabled an additional condition that's in front of you on the table, and that condition is here that in addition to the conditions on the report, and in addition to amending condition 2 to refer to that additional drawing, because that isn't in condition 2 on page 83, because we didn't have it when we wrote the report. So amend condition 2 with that additional plan that shows you, but also put this additional condition on. You can see what it says in front of you, is that prior to the commencement, we'll have to agree details of the construction, make up the existing wall, and where the repairs will have to be done. And we'll obviously get our conservation staff to scrutinise those details when they're submitted, so we make sure the wall's done in the best possible care and attention. But other than that, it's simply a restoration project, which, as I understand it, hasn't attracted any objections and we're recommending approval. Thank you, members.
Okay, thank you. I move the officer recommendation. Give a second to Councillor Beard. Thank you. Members, any observations or questions? Councillor Beard.
I just wanted to know, the conservation officer has been on the call for 2 hours and 40 minutes. I just wondered if she wanted to make any comment on this application.
Thank you, Chair. Now, I think Graham has covered all the bases here, and I think this condition would make sure that we go ahead with proper refurbishment of the wall. And it's a very important wall, and we want to reinstate the railings as they were, as we have historical photographs of. So, yeah, there's nothing else I want to add, but if there are any questions, I'm happy to take them.
Well, hopefully it's been well worth waiting for. And thank you for your forbearance. Councillor Beard.
On that basis, it has my full support.
Thank you. Councillor Winkles.
Thank you, Chair. I'm totally behind this, especially with the amendment that's been put in. It's certainly going to enhance the heritage aspect of Sittingbourne High Street, which we greatly need. Thank you.
Thank you. So members, put this one to the vote then. Those in favour? And that's unanimous. Thank you, members. So permission is granted. Can somebody call back? So members, we now move on to part 5 items, and are there any comments or observations? Councillor Beard, didn't even look.
Well, this one's in my ward, and reading it, I do have serious concerns. It's the item 5.1, which it was only dismissed on the grounds that we hadn't sought a SAMS contribution. And we've mentioned this before, that on applications that we're refusing, we don't ask for the SAMs, so that the applicant doesn't get a chance to say whether they're prepared to pay for it or not. So I'm kind of amiss there that all the other reasons for the refusal seem to have been dismissed by the inspector. So actually the application was acceptable apart from the SAMs payment, if that's how I'm reading it. And if that is the case, it should have really been approved even by us or by the inspector with the SAMs payment applied. But I don't know if that's in the remit of the inspector to apply it afterwards.
Well, I mean, I'm not familiar with this case because, as you know, it's in your ward, not the area I deal with. But if we think there are sound material planning considerations for refusing planning permission, then there's no point in asking someone to send the money in if they're not going to get the benefit of that, because the administrative cost of sending the money back, etc., is just not worth it. So we tend not to ask for people to send the SAMS payment until we've decided to approve something. But obviously, you haven't approved it, then we have to make it clear to the planning inspector that he or she isn't really entitled to approve under the Habitat regulations either, unless that payment's been made. And the problem is that once you get an appeal situation, the planning inspector, well, they tend to view that unless I've got the money in front of me or a mechanism to deliver that money in front of me, I can't dream it up. So it's a bit of a funny situation. If you were the applicant, it's very frustrating that in this case, the inspectors agreed with your case entirely, but because you haven't already got the money on the table or haven't prepared a draft unilateral undertaking, you can't get it. So the situation now would be he'll probably just apply again with his money and it'll go straight through. But it is a frustrating, the whole system is a little bit frustrating, but it really isn't any point in asking for money where we're going to refuse something. That would look ridiculous, I think.
Yeah, just bring our legal officer in, Cheryl, please.
I think just to add to what Mr. Thomas was saying, under the Habitats regulations, there is a requirement for the competent authority to assess the impacts on the SSSI, the SPA, etc., etc. At the point that the Borough Council is determining the application, they are the competent authority. But at the point that that application goes to appeal, that competent authority becomes the planning inspector. So he has to carry out his own appropriate assessment, and he has to determine whether or not initially there are impacts on the SSSI, the SPA, what have you, and then he has to then consider whether there is a way of mitigating those and whether that then becomes acceptable. We have got the Birdwise scheme, which is our scheme that we're signed up to with all the other North Kent authorities. The inspector would have been wise to that, and it would have been within the gift of the appellant to say, I am happy to pay this sum of money and I will make an arrangement to do so. How can I go about it? Or, as Mr. Thomas said, to submit a draft unilateral undertaking to the appeal. Quite regularly in legal, we see draft unilateral undertakings coming in for appeals, and we're asked to check them and do they do the job they need to do? Are they good enough? More often than not, especially if I get hold of them, I make quite a lot of comment on them and they go back saying actually they need a bit of work. But, you know, I would imagine in this particular instance, the inspector was not satisfied that, as Mr. Thomas said, there was a mechanism, be that an agreement to pay or a unilateral undertaking, and it would have been within the gift of the appellant to do that at the point they submitted their appeal, because they knew through, you know, where they are, it's well publicised. Most applications in Swale are caught by that 6 kilometre radius from the SPA. So it's not something that happens here and there. It's something that happens on an awful lot of Swale applications. So it's something that, you know, people should be wise to. And I think, you know, it's come before committee, this question before, hasn't it? People, if they do the homework, they know I'm going to get caught by this. If I think I've got a good case at appeal and I think I can win this one, I need to kind of make sure that I've secured that as well, because it's an easy sort of way to say sorry, no, isn't it? Because you haven't actually paid that money. So I think hopefully that answers the question a little bit.
Thank you. Councillor Beattie, you just want to come back?
Yeah, that does answer the question. And I just think perhaps certainly developers would know that, but I think possibly householders might be less likely. And I don't know the exact circumstances of this one, but if they were just a householder, because it was a very small application, they might. My other one was on 5.5, which is also in my ward. That's the first time I've come across an inspector disagreeing with our reasons for refusal again, but was worried about the loss of the first floor residential flat due to our lack of 5-year supply. So he's trying to stop us converting a flat to something because we haven't got a 5-year supply. That's the first time I've come across that. And I do think, again, I suspect that applicant, I think they might have already actually got an application back in for that. So I suspect that will be coming to us again. But it just as a very strange couple of decisions that I scrawled over to try and work out what was going on.
Yeah, they're not unusual either. Councillor Dender, please.
Yes, that's my point was really answered. I was just going to mention escrow, but a unilateral undertaking, I understand, would have just sufficed just as well if they bothered to put it in. So the inspector knew at least something was there.
The smarter applicants are putting these unilateral undertakings in with some applicants, to be fair, just won't listen. And they just think they'll bulldoze their way through the system, come what may, and they just don't care. And they get caught by this, and then they learn. But other people play by the rules, and they're smart, and they can have their appeal approved because they put in place the commitment to pay the money should it be approved, and the inspector can deal with it. But he says in 12, in his paragraph 12, I just haven't got it in front of me. Yeah.
Thank you. And I've just got one other, which is item 5.2, which is Pebble Court one, and I don't know whether our legal officer wants to say anything about this one. This is the Woodgate Lane.
Yeah, I would only just say that I do remember this one. I remember it coming to committee. It was one of our remote meetings during the period of lockdown. And just that since that decision was taken by the committee, that they did not accept that the building was in the use it was claimed to be in to allow the permitted development rights to be afforded, that there has been some fairly significant case law on that particular point. It's a case called Smolas, Very exciting name, but it's basically determined that the local authority in assessing applications for prior approval to the carrying out of permitted development rights needs to do effectively a qualifying assessment to start with to determine that the lawful use of that building is established at the point in time it needs to be, to allow that prior approval application then to be considered. Because I think, if I remember rightly, it was Mr. Thomas's application and we had photographs of a car inside the building and desks and paper bits strewn around and various things and evidence from neighbours that it had never been in an agricultural use. And there were some sort of difficult debate and discussion at the meeting, because I remember coming in and trying to explain, hopefully fairly clearly, that we needed to do that initial sort of stage first. And I think the committee took that on board and refused the prior approval application on that basis. And that's obviously been upheld at appeal. So.
Good members, it's been a long evening again. Thank you all for your indulgence. And I said there's been some difficult ones, some easy ones tonight, but safe journey home, and look forward to seeing you all next time. Thank you, members.
Good night, all.